Hello, my name is Mandy Barstow, and today we're going to be looking at discrimination in the workplace. In this session, we are going to look at the commitment to equality and diversity and what those words actually mean, the legal rules on discrimination in the workplace, what is meant by harassment, the expectation of us all in a workplace conduct, and the recent changes to the Equality Act 2010. So what does equality mean? From a business perspective, equality represents the aim that everybody should be treated equally and fairly. And what does diversity mean? Diversity acknowledges the variety of differences in the world, emphasising the importance of recognising, valuing, and embracing them positively. And the purpose of this training is not to ignore these differences, but to appreciate and engage with them constructively. First of all, we're going to actually look at the Equality Act itself. So it's the Equality Act 2010. And the aim of that act is to ensure all employees are treated fairly and work in an environment free from harassment. And its goal is to create a fair and inclusive workplace. It also protects certain characteristics, and there are 9 of those, and we're going to look at those in the next slide. The 9 protected characteristics are age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, and sexual orientation. So what is discrimination? The definition of discrimination is unfair treatment based on actual or perceived characteristics, and it can take many forms. One of these forms is indirect discrimination. So what is indirect discrimination? That's when a rule or policy applies to everyone equally, but puts certain people at a disadvantage because of a protected characteristic. So a simple example of this is a company has a rule that all employees must work late on a Friday. This seems fair, but could disadvantage employees who can't work late because of religious observations or childcare responsibilities. So the key message here is even neutral rules can be unfair if they affect some groups more than others. The next one is direct discrimination. So this is when somebody is treated unfairly as a direct result of a protected characteristic. Again, simple example, a manager refuses to promote a qualified employee just because they are over 50 years old. This is direct discrimination because when someone is treated unfairly because of a protected characteristic, in this example, age. As well as all the other rules, disability actually has 2 separate rules to itself. The first one being failure to make reasonable adjustments. So this is where employers must remove disadvantages for disabled employees caused by workplace rules or physical barriers. For example, adjusting work systems or providing special equipment so that they can do their job properly. And the other one is discrimination arising from a disability. This happens when someone is treated unfairly due to something connected to their disability, but not the disability itself. For example, Jane has frequent absences for MS treatment. A strict attendance policy disadvantaged her unless adjusted. So again, the key point is that employers must ensure policies and systems are fair for disabled employees. Now we're going to look at harassment. The definition of harassment. Harassment is unwanted behaviour related to a protected characteristic that 1. Violates somebody's dignity, or 2. Creates a hostile, intimidating, degrading, humiliating or offensive environment for them. It doesn't matter whether the behaviour was intended to cause harm. What matters is the effect that it has on the person experiencing it. For example, offensive jokes or comments, inappropriate physical contact, excluding somebody or making them feel unwelcome. So the key points of harassment is that the protected characteristics in this one, the main ones are age, sex, sexual orientation, gender reassignment, religion, belief and race. Let's look at the key points of harassment. The protected characteristics, the main one in this are age, sex, sexual orientation, gender reassignment, religious belief, race, and disability. Sexual harassment covers behaviour of a sexual nature or poor treatment after somebody submits to or rejects such behaviour. And what matters here is it's not just about the harasser's intent, it's the impact on the victim that counts. And what might seem like banter to one person can feel uncomfortable to another. So the victim's perception is central when determining harassment. Examples of harassment you might not realise as compliments. So, for example, repeatedly commenting on somebody's appearance in a way that makes them feel uncomfortable. Banter, example, it's just a joke, comments that offend or upset somebody. General comments saying, you're too old to understand technology to another colleague. Group jokes, sharing or laughing at jokes that stereotype a person's religion or background. Indirect behaviour, a group of employees joking about racial stereotypes. The comments aren't directed at anyone, but another employee overhears and feels deeply uncomfortable. Key messages, what might seem harmless to one person could feel offensive or intimidating to another. There is an ever-increasing harassment online or on social media. So examples of harassment online are sharing offensive memes, videos, or messages in group chats, sending overly informal or inappropriate messages to colleagues, using excessive capital letters or exclamation marks, which may seem aggressive. The key challenges here are the tone and the intent are harder to interpret in written communication, and harassing behaviour can occur unintentionally when informality crosses boundaries. Think before you post or share anything online. Ensure your communication is respectful and professional. Victimisation now. So what is the victimisation? Definition of victimisation happens when someone is treated unfairly because they have 1. Made a complaint about discrimination or harassment, or 2. Helped someone else make a complaint, example being a witness or giving evidence. It protects people from being punished, bullied or treated badly for standing up against unfair treatment. And an example of this is an employee excluded from meetings after supporting a colleague's discrimination complaint. As I said at the beginning, there have been some changes to the legal framework in the Equalities Act 2010. So previously, UK law required employees to demonstrate that they had taken all reasonable steps to prevent harassment, but only after an incident had occurred. This reactive approach often left significant room for legal challenges and did not sufficiently prevent instances of harassment. The recent amendment to the UK law, which came into effect on the 26th of October 2024, introduces a proactive duty for employers to prevent incidents of sexual harassment. This legal shift moves from the focus of merely responding to harassment incidents to actually actively preventing them. It mandates a more proactive approach requiring businesses to assess risks and implement effective measures to create a safer working environment. This change reflects a growing recognition of the importance of the proactive measures in maintaining workplace safety and dignity. So what are definitions then of reasonable steps? So under the law, reasonable steps might include establishing and enforcing a robust anti-harassment policy, conducting regular training sessions for all employees to understand what constitutes harassment and how to report it, implementing clear and confidential reporting response mechanisms, performing regular risk assessments to identify potential risks in the workplace, environment and culture. Another critical change is the extension of an employer's duty to prevent harassment not only by employees, but also by third parties such as clients, contractors or visitors. This broadens the scope of an employer's responsibility significantly. The consequences of non-compliance. Failure to comply with these new obligations can lead to more severe penalties. For instance, if a case of harassment goes to tribunal and it's found the employer did not take necessary steps to prevent it, the tribunal can increase the compensation awarded to the complainant by up to 25%. Additionally, all non-disclosure agreements can now not include sexual harassment disclosures. This promotes transparency and accountability. So what are the next steps then? It's essential for employers to review existing policies and procedures, implement training, conduct a risk assessment, monitor and evaluate. Thank you for listening today, and I hope you have learned something from this training. If you have more questions or any questions at all, please feel free to reach out to your business partner, who will be more than happy to help. Thank you for listening.